Today is video one of a several-part series on disability asset protection. Specifically, this is part one of two on special needs trust and supplemental needs trust. In this video, we're going to talk about who these special needs trusts are for and what are they used for. In next video, we're going to talk about the differences between the special needs trust and the supplemental needs trust. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please do hit that like and subscribe button. It really does help support the channel. Also, a couple caveats before we get going. First of all, these videos are for educational purposes only. I am not giving legal advice. And second of all, we're going to be talking about Minnesota law here. If you live in another jurisdiction, make sure to talk to an estate planning professional in that jurisdiction before you plan your estate. So, disability asset protection. What we're doing with disability asset protection is generally we're putting assets in trusts for persons who have disabilities and are on government benefits, and we set it up so that the trust assets can be used to supplement the government benefits that the individual is receiving. It's kind of a complicated topic. We're going to break it down into two videos shorter than 10 minutes. There's a lot more we could talk about, but let's just get the overview today. So the big question is, why do we have them? So if you have a qualifying disability and you are on government benefits such as Medicaid, then we're looking at a trust for these individuals. Now, Medicaid is a federal program that is run by the states. In Minnesota, we call it medical assistance. That's what the Minnesota version is called. One of the key factors for just about just about every government benefits program is an impoverishment requirement. There's an income impoverishment requirement and an asset impoverishment requirement. We're going to focus on the latter. Generally, to qualify for medical assistance, you have to be impoverished in your assets below a certain level that is based on the federal poverty guideline. It depends on the program you're in, but generally it's going to be you have to have assets under $2,000 to $3,000. That's your entirety of your assets. Now, there are some exceptions. For instance, if you have a house, houses are accepted and considered unavailable and are not considered in the calculation of how many assets you have. There are other exempt assets as well, but that's a whole nother conversation. There are two times that you need to qualify under the impoverishment requirement and, of course, other program requirements. The first one is when you are initially qualifying for medical assistance or another government program. You have to have your assets below a certain level, and then usually on an annual basis, you need to re-qualify and show that you have assets that are under the maximum assets. Now, what happens if you have more assets than is allowed? Let's say instead of having $3,000, you have $100,000. Well, in that case, you're going to have to do what's called a spend down. You're going to have to spend your assets usually on qualifying expenses, such as paying for your own medical bills for a certain time until you get your assets below the maximum amount of assets allowed. So in estate planning, this leads to a situation that we run into a lot of times that we try to avoid. Take Bob. Bob has a qualifying disability. He is on medical assistance. His grandmother, Susan, wants to leave him an inheritance, and in fact, does so, and she passes away, and he inherits $100,000. If Bob has $100,000, he doesn't qualify for medical assistance. He'll be kicked off the program, and he'll have to pay for his own benefits until he has reached his impoverishment amount. Basically, the inheritance that his grandmother was giving him is going to go directly to the government without improving Bob's life. And I'm sure that that's not what the grandmother wanted. So what we do with disability asset protection is instead of giving the assets directly to the individual on the government benefits, we put it in a trust. And if it's done right, these assets can be used to supplement the lifestyle of the individual on the government benefits. Now, there are three core rules for these trusts. There's other requirements as well, but these are the three core ones that you want to keep in mind. first of all, is you cannot use the assets of the trust to duplicate the government benefits. If you get money for food from a government benefit program, you cannot use the assets from the trust to pay for food that would normally be received or paid for through the government benefits. That's called duplication. You're not allowed to do it. So if you can't use it for certain things, there are a host of other things that you generally can use the assets in the trust for. For instance, extra medical. Dental care is generally not covered under government benefits. Acupuncture, experimental treatments, extensive treatments, often not covered under the government benefit programs. Special equipment, certain wheelchairs, for example, or modifications to vehicles will not be covered under government benefits, but a special needs or supplemental needs trust will be able to cover those costs. Travel and vacation. First of all, the government benefits do not cover your travel to, say, the Grand Canyon. However, you could use the assets of a trust to do so, and generally you can use the assets to pay for a companion if the companion is necessary for the care of the individual. You can use the assets of the trust for education, such as for employment. You can use it for entertainment, though, mind you, entertainment would be like a baseball game ticket or a football game ticket or a movie, not for food. Because food is covered by the government benefits. You could use the assets in the trust for professional services, such as legal expenses, such as a CPA or a bookkeeper. And finally, you can use it to pay insurance premiums, such as life insurance if you have those continuing, or some other insurance you may have. Rule number 2 is sole benefit rule. You have to use the assets of the trust for the sole benefit of the beneficiary. You can't just use it for the beneficiary, and you got to use some of the assets for his friend or whatever. Pay for movie tickets for the individual and the individual's girlfriend. You can't do that. It can only pay for the individual. Rule number 3 is no direct payments, and this is one that's often screwed up by a lot of people. And here's how. The individual that is on the government benefits and is the beneficiary of the trust will go out and say, buy tickets to a football game. And it'll come back to the trustee and say, hey, trustee, I bought the tickets to the football game. I'd like to get reimbursed. And the trustee will have to sit there and say, no, I can't do that. I cannot pay you directly from assets of the trust. You cannot reimburse the beneficiary for expenses. The trust assets must be paid directly to the vendor. Cannot be passed through the individual, even if it's penny for penny. That is very simply part 1 of 2 parts on special needs and supplemental needs trusts. This is what they were for. Next time, we're going to talk about who can qualify for a supplemental needs trust and a special needs trust, and what are the differences between a supplemental needs trust and a special needs trust. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. It does help support the channel. We also do a new video every other Wednesday, so stay tuned for that. If you have questions, leave them in the comments below or just send me an email. Otherwise, until next time, this is Gregory Singleton with Signature Law.